Well, hello, everyone. I am excited to present to you today Kara Gansmann with Cranfill, Sumner. She is a specialist with elder law, and she is going to speak upon today on the differences between wills and trusts. My name is Desiree Whalen. I'm with the Whalen team of Keller Williams Innovate, and I am a certified real estate planner. Um, and how that works is I was involved with training of 4 different areas, and the one being estate planning as one of those fields. And she has, of our lunch and learned, Kara's is probably the number one that most people come and visit and listen to our lunch and learns, because she does provide some really valuable information, and it's all centered within North Carolina. So just to put that out there. Um, so what I'm going to do is reintroduce her, and she's going to take over and present about wills and trusts. And then we will leave enough time so that people can have some questions.
Okay,
Okay.
thank you.
All right. You go right ahead.
Oh, thank you, Desiree. I appreciate it. I always love talking to your group, mostly because they have good questions. But this is a topic that I love. I'm an elder law attorney. I practice exclusively in elder law. There are components to elder law that involve trusts and wills, and probate or administrating someone's estate. And so those are topics that we'll be touching on today. We're really focusing on the number one question that people ask me, which is, do I need a will or do I need a trust? And it's such a great question because there's a lot of information out there that people are hearing from friends or family members, or I'm hearing things on the radio now. Financial advisors are sometimes touting trust as being a good way to transfer your estate. And so I think there's a lot of information out there, whether it's correct or not. It really, that information is so particular to you and your circumstances and your assets and your goals that it's not a question anyone can just say right off the bat, oh, a will is the way to go, or a trust is the way to go. And so, what I want to do is talk through the differences between what each document can do and what it will do for you. The considerations that I make when I talk to clients about having a will or a trust, and then ultimately be able to guide you a little bit, not personally, but in making some of those decisions and how you might approach that. Um, I'll start first with a will. Most people tend to know what that is. It is a legal document that is created with the intention that on that person's passing or their death, that that will or that legal document serves to inform others how the deceased person's assets should be handled and transferred to others. The will can give explicit instructions to say, I want to sell my real estate, and then everything, this is how I want the proceeds to be used. Or the will can specify certain items like jewelry or cars to pass to people, or bank accounts and other assets. Um, a will can be helpful in making sure your intent is known and appointing an executor to do that. Um, Often when you have a will, you will have to go through a process called probate. It's a legal process. And probate is here in North Carolina, the process where someone can take the will of a deceased person to the courthouse in the county where that person had lived and apply to be executor. They present the will to the court, our clerk of court. And then from there, they are given permission from our court to serve as executor or administrator of the estate. And that person can take the documents that the court gives them and go to a bank account, transfer those accounts from the name of the person who passed away to the name of the estate. Under North Carolina law, those accounts have to be used first to pay off certain debts and expenses that the person who died had before their passing. And so there are certain rules that have to be followed in handling the estate assets. Uh, Once those debts have been satisfied, then and any other obligations like taxes. Then those assets that remain are divided pursuant to the terms of the will. That is a very general uh, process or outline of how probate works. Um, and probate here in North Carolina doesn't have to be a difficult process. I don't think it particularly is. Um, if the assets that are passing through probate are under $20,000, it's usually an abbreviated process, pretty short, maybe 30 days. If the assets exceed $20,000, then it's a fuller process, and that process might include running a notice to creditors in the newspaper to inform any creditors out there that the person has passed away, and if they're owed money, that they have a certain amount of time or a specific date, they need to present their claim or their debt to the executor in order for that to be satisfied under our laws. Um, but sometimes there people will always say, well, how do I avoid probate? And this is even without a trust. Sometimes there are assets that don't pass through probate, even when you have a will. And those are accounts that you might own jointly with others. So typically, if you are a husband and wife and you have a joint financial account, those accounts don't pass through probate when one of you passes away because you have a surviving owner. Um, Things like beneficiary designations on life insurance policies or retirement accounts, those typically don't pass through probate because we have a beneficiary named. Real estate that is owned with other people sometimes won't pass through probate if you own that property as right of survivorship with another person. When one person dies, the surviving owner wouldn't pass that property through probate either. Um, so there are certain things that don't always pass through probate, but the things that might include anything in a person's name that isn't owned with other people. Um, Anything in a person's name that doesn't have a beneficiary designation, anything that's not in a trust. Think about even having a vehicle out there that's in someone's name. If it's not owned with anybody else, that is an asset that would pass through probate. And so when the owner of these things passes away, in order to give legal title to someone else to handle these assets or to transfer them to the new heirs, that's why we go through probate. Um, Here in North Carolina, for those larger probates that exceed $20,000 in assets, the process is going to be a minimum of 91 days. Um, and that's just due in part to the notice to creditors period, which is a required 90 days to allow creditors to come through. I don't think it's truly reasonable to expect the estate to be wrapped up in the 92, 93 days. I think really giving our courts a little time to review everything. I think it's reasonable to expect for a fuller probate, you could spend anywhere from uh, 2 to 3 months to maybe 6 months, sometimes longer. Um, that doesn't mean the estate is frozen the whole time. It's just that certain assets during the notice to creditors period shouldn't be spent until we've assessed the debt to asset ratio. Most of the probates that I conduct for my clients, they last anywhere from 4 to 6 months. If it's a little longer, it's usually due to taxes, where we want to make sure and follow North Carolina and federal law that taxes are paid. And sometimes those taxes, the tax documents don't come around until this time of year anyway. So on occasion, there may be estates that last a little bit longer, and it's usually because we've got a few outstanding tasks to conduct, but that doesn't mean the estate is frozen the whole time. We can often make partial distributions as long as we've reserved funds available to satisfy any debts that might remain. But the executor is the person or the administrator is the person who gets to administer the estate and reports to the court to the penny exactly what assets are passing through the estate, what debts are being handled by the estate assets. A lot of this is just good record keeping, keeping receipts, presenting these to the court. Those have to be shown to the court in support of how the estate assets are handled. Um, Often in probate, there's a big question from my clients about the expense. Um, Probate fees here in North Carolina, I think are generally pretty inexpensive. There's a range. It's a small percentage of the estate that the state of North Carolina will charge. And again, that's for the assets that are transferring through probate. Um, and it's 0.04% of the estate. And so generally, for most estates, there may be probate fees that are a few $100s that can be paid for from the probate estate. Here in North Carolina, we cap those fees at $6,000, and that's essentially meaning if you have an estate that's 1.5 million or greater, you're not going to pay any more than $6,000 to the state of North Carolina in those probate fees. Probate fees are a little different than attorney's fees. There isn't a cap on that. They still have to be fair and reasonable and clearly not excessive. But but in general terms, the state of North Carolina does charge an estate in order to oversee the process. And we have to satisfy the laws. And that's why a clerk of court is there to make sure that the executor is following the laws. Um, it's a pretty straightforward process. With that said, because you have to transfer everything to the penny and be able to account for all the receipts, and there are deadlines and forms to submit, sometimes people start to say, well, maybe probate isn't that is something that I'd like to avoid. And that really leads to the question that most people have. Well, is the better way to do that with a trust? So, a trust is a legal document that, similar to a will, serves to pass assets on your death. But interestingly, a trust is a legal document that can also serve to inform a trustee how to handle assets during your lifetime as well. So it is effective not just during your lifetime, but also after you've passed. And I like to think about trust as an instruction manual. It's telling someone how to handle your things for you at any given time. And so you can be your own trustee in many cases. Not all trusts, but in the trust that I'm thinking of in this case, a revocable trust, you could be your own trustee. You want to choose a successor trustee if you become incapacitated. And then you can outline how you want your assets handled for you at any point. The biggest the biggest and the most important part about having a trust is not just writing the document, but actually following through and retitling the assets into the name of the trust, which means if you have a trust, you will want to retitle your bank accounts into the name of the trust. You will want to transfer title in your home to the name of the trust. Um, you will want to convert ownership of things or name the trust as the beneficiary of things so that you can make sure that that trust governs those assets. So that on your passing, it's the trustee who does not have to go through probate with those assets and simply has to follow the instructions you've laid out in the trust. Um, if you don't fund the trust, then you have wasted your money. Um, and you will have to go through probate to get things to trust. And that's why having a trust, there's some complexities that a trust has that are far more complex than a will, but it requires a little more follow through than just signing the document. And that funding process, that retitling of assets is the part that is so crucial. If you have a trust, following through and funding it can be so important, or else the work you've done and the money you've spent is wasted. So in counseling clients through whether a will or a trust makes sense for their circumstances, there's a couple of approaches I look at. And I tend to call this a dollars and cents conversation. So if you think about the dollars perspective, I may talk to clients and I may say, let's look at what you own. What are the accounts that you own? How do you own them? Do you own them with others? Um, because my thought is I'd like to find out how those accounts would pass, whether there was a will or a trust involved. Um, And ultimately, on the dollar side of that ledger, um, if we are passing those through probate, then I want to weigh is how much is that going to create probate fees? Is that going to increase probate fees? And ultimately, is that person going to pay more in probate fees uh, to transfer things through a will than the cost of paying for a trust? And so I kind of weigh that with my clients, and there isn't a particular dollar amount that makes sense to them, but I start to, because every attorney is going to charge a little differently for their services. But for me, I kind of weigh uh, what would pass through probate, what would the probate fees be for certain assets, and in comparison to a trust, is it worthwhile for them to consider paying for a trust and paying up front than to allow these assets to go through probate and having larger probate fees? So on the dollar side of that conversation, that's part of what I examine. What's passing through probate? What would be charged for probate fees in comparison to the cost of a trust? But in this dollars and cents discussion, when I talk about the cents, I'm not talking about nickels and dimes. I'm actually talking about what makes sense for their plan and the people involved in their plan. And that's where I tend to get fairly nosy about the people in your life and the people that you're leaving your estate to, because different people have different ideas about how their estate should pass. Um, Everyone's circumstances are going to vary in this regard, and that's why it requires serious conversation about what assets are passing and who's receiving them and how they're receiving them. So thinking about blended families, for example, if you have if you're married to someone but you each have kids from different relationships, a trust may be a helpful tool in making sure that you can provide for your spouse under certain conditions and parameters and still be able to provide for your children either on your spouse's death or at the same time of your passing, even if your spouse has outlived you. um, a trust can be very helpful in making sure that uh, spouses have certain rights to things, and that and that people's children then have rights to what remains in trust. So trust can be very helpful for blended families. Trust can be helpful for you if you are passing your assets to an heir who also needs their assets held in trust for them. And these are people who have lots of different circumstances. For example, if you have minors who are inheriting from you, and especially young kids, um, that you expect you will hold their shares in trust for a long time, even if they're over 18, if you think you might hold their shares in trust into adulthood, that may be somebody to think about, not just having a trust built into your plan for them, but creating a living trust for yourself to avoid probate that passes things through probate and then passes things to another trust. Um, if you have heirs who have special needs, if they're disabled, and these are intellectual or physical disabilities, um, if you have an heir who is in a nursing home, for example, the last thing that we may want for them to inherit is additional money that would be spent down on their care when there might be other alternatives to pay for care. If you have heirs who might be uh, financially irresponsible, that would be a good reason to hold their share in trust. If you have heirs who have shaky marriages, that would be a good reason to hold their shares in trust. If you have heirs that have chemical or substance abuse in their life, that might be a reason to hold their shares in trust. So the circumstances of your heirs start to become important in how you're passing assets to them and how you want them to access those assets, under what conditions and circumstances. Additionally, you might want to think about who the trustee is for those people who manages those funds on behalf of the heirs or the beneficiaries. Um, when you think it too about whether a trust makes sense, I often ask folks if they have real estate outside of North Carolina, because in my mind, that instantly creates the suggestion that a trust is the better vehicle for them. And here's why. If you own real estate outside of North Carolina and you pass away, you will have to go through probate here and establish a domiciliary probate, and then have a separate probate in that state to transfer title of that property, and that's called an ancillary probate. And so when you're looking at the need to go through probate in two different states, where the probate fees can certainly increase with that, that's when we start to think about what makes sense. A trust would make a lot of sense. Unless someone's saying, well, we're selling that property right now, we're not going to have that when we pass. Um, Long term, I think a trust certainly makes sense for out of state property. Trusts can be named as beneficiaries on retirement accounts or insurance policies. There are some tax ramifications for retirement accounts or qualified funds, but there are things that we may want to consider naming that trust as a beneficiary of different accounts as an asset protection planning move. But in large part, that is where I would talk through clients about some of the differences between wills and trusts, and I talk about their circumstances and uh, find out which one of these vehicles better fits their needs, in particular in light of the heirs that they're inheriting. Um, Trusts inherently, because they're funded and when they're funded, do avoid probate, and that can be an exceptionally smooth and seamless process for your heirs and your loved ones when you've passed away to not have to jump through those hurdles. You don't have to run a notice to creditors in the newspaper. In essence, the trustee may be selling a home for you after you've passed, and then the money can be used to satisfy debts, and then otherwise distributed to your heirs. And so even though sometimes I think trusts are more of a want than a need, and those are where we would talk about that, they can be very helpful. If you have a trustee who doesn't live locally, um, giving them the authority as a trustee to manage your estate and administer a trust as opposed to going through probate can be a very convenient tool for them. I've talked with a lot of clients who believe that when their parents passed away and their parents had a trust, everything was just so easy for them, even though they didn't live where their parents passed away anymore. Um, I don't know if there's a price tag you can put on convenience, but a trust is a great way to avoid probate and those inconveniences of having to respond to court deadlines and file forms. But I think by and large, those are the two main vehicles that people use for estate planning. Short of sometimes do it yourself self remedies, which is naming beneficiaries directly on accounts. Um, there's some risk sometimes in doing so, and that's where even without a will or without a trust, you're avoiding probate, which may be somebody's main goal, but their unintended consequences of self-help remedies may be detrimental. And I think about people who might have life insurance policies or bank accounts or retirement accounts where they've named minors to receive those funds. It's their intent that those minors receive those funds, but if those minors are still minors at the time that they do receive those funds, there's going to be a lot of um, court proceedings in order to protect those funds for the young person who can't legally hold that much money or sign and consent to receive that money. So I know folks think that, oh, well, we'll just name these people and I don't need a will or a trust because I've named beneficiaries. You have to think through those unintended consequences and see if the people you've named are capable legally of accepting funds. Um, if you've got adult people and you've named adults as beneficiaries on accounts, then that's certainly a self-help remedy that uh, doesn't fit squarely within a will or a trust. But I think you want to think through exactly, does that still match your estate planning needs and goals? So far, what questions have we got on those concepts or topics?
I have kind of more of a statement And there was a group I was working with, and they had just a will, and the executrix, that's how you say it,
Yes.
didn't realize that everybody has to sign off on everything. And they were trying to keep a brother out of it and not get anything. Well, it poses a lot, it posed a lot of issues because not only were some of them married, you have to get the married person's involvement now with it. Not everybody was on the same page.
No, so was that Desiree in accordance with selling a piece of real estate that
Yes.
yes. So you have hit the nail on the head. As part of a probate, when real estate passes through probate, here in North Carolina, t rights and interest in real estate vests in the heirs instantly on a person's passing. And so the way I explain this to clients is that when they pass away, even before anyone knows that they're not here, their interest in the home passes to their heirs. Now the deed doesn't magically get changed. And so it's the process of going through probate that gives clear title to those heirs to be able to sell the home. But you're right. It's not just the heirs who are selling the home. North Carolina law requires their spouses to sign off on the sale to acknowledge their marital interest in the home. And if the home it doesn't have specific uh, instructions in a will, then yes, it gets divided among all the residuary heirs, and their spouses would have to sign off on the sale. And so that's when sometimes if I've got clients who are looking to leave real estate to charities, for example, or they have heirs who don't get along or don't know each other, or just a significant number of heirs, I will usually include in a will, if they aren't using a trust, I'll include an instruction in the will that the executor has the sole authority to sell the real estate, and those funds would then be divided. Because it can be a real nightmare, especially in your position. You're just trying to deal with the person you're dealing with. You don't really want to get involved in the family dynamics, but I'm sure you get dragged into that.
Um, there is a question here, and if you don't feel like doing your question off mute, you're more than welcome to share it on the chat. And there are two. One is what's the difference between, how much difference is it between Virginia and North Carolina?
So I'm not licensed in Virginia, so I really can't tell you what there's a difference, if any. Every state will have its own differences between uh, their laws and administering things, their processes. Um, Typically, if clients are coming to me from another state where they have documents drawn up, I will look at those and I will try and pick through the nuances that I do understand. Um, if you have a will from out of state, there are extra steps that someone will have to, your executor will have to do in order to have that out of state will accepted here in North Carolina. Sometimes that means having to track down the witnesses if you can find them. I think about a case recently where we had a 1982 will that was typed, and the witnesses we couldn't we their names weren't typed. We just have signatures. So tracking down these people who, assuming they're still alive, um, it can be difficult. But even so, with an out of state will, you could also have an attorney in that state sign off and say this was executed in accordance with these laws at the time. More and more, I'm getting bills for those from these out of state attorneys who want to charge my client $500 to write to sign off on an affidavit that was valid. And so there are some extra procedural hurdles that the executor will have to encounter in order to have an out of state will admitted for probate. Sometimes, though, the hard part is that if I'm not, because I'm not licensed in all 50 states, I just don't know what the differences between those laws are. And if that will requires us applying Virginia law, for example, I can't tell you about the unintended consequences of using Virginia law to follow some of the procedures that are required.
The next question is, to that point, can a life estate be drafted within the trust?
Um, the way you've asked it, no, but the point I think is that's trying to be made is yes. Within a trust, you can outline that property may be used for the duration of someone's lifetime, and you can outline the parameters that they may use that property and their obligations or expenses that the trust would pay or that the other person should pay. And so, yes, you can provide for someone's use during their lifetime of property within a trust. And that trust could even be within a testamentary trust within a will as well.
Well, what about can you go back to your point about property held, let's just say in New York, I'm down here, and it's an LLC and it's amongst three partners, three sisters, and they're in different states. So would an ancillary proceeding be necessary, or
Not in
is the
that case.
disposition of that written into the LLC?
Well, that's exactly it. The LLC owns that property, and if one of the sisters passed away, their interest in the LLC passes through their probate or a trust. But we don't have to have an ancillary estate because the real estate is not in that person's name. It's in the name of a LLC.
And that can also be drafted that the LLC reverts to the two remaining sisters if that's a potential, and
Correct.
then from there directed. But that specific agreement um, regulates that the terms of
Correct.
that is attached to that in giving
Correct. The
you
operating
direction.
agreement controls
Okay.
those assets.
What do you, I know I'm skipping ahead, but I'm interested in what's your fees? If you go for, you don't want to die intestate anywhere. So obviously you definitely need a will. And in some cases, in our particular situation, which we'll talk later, it's trust. But let's say you're doing the whole package. You're doing the medical directive, the financial power of attorney, and the whole package. What's an estimate? And does that go by complexity or market value?
It doesn't go by market value. I usually tend to work in flat fee costs, and that is either based on an individual or a married couple. And those will range anywhere from $1,400, which includes wills and powers of attorney and healthcare proxies and living wills. Um, or more expensive trust plans can range from anywhere from $4,400 to $10,000, depending on
Okay.
the kind of trust that you're getting. Um, so they are pretty specific to some of these circumstances, but not based on market value.
Okay. Great. Thank you.
Mhm.
Do we have any other questions?
Not yet.
Those were great questions, though. All right. So in order,
Wait a
so
minute.
go ahead.
I'm sorry,
If
Jerry's
we have a
interrupting me.
will that's drawn up in another state, should we have it redrawn here, or what's the procedure?
I think you should have it reviewed here. If you have an out-of-state will and other documents, you should have them reviewed here um, to understand a few things. If your intent is still the same, obviously your circumstances have changed. And so it's always a good idea to have somebody review them with you to make sure that your intent is still the same. The people you've appointed to these roles are still the same. Your geographical proximity has changed, and so it's certainly worthwhile to review that as well. It really depends what these documents say and how complex they are in determining whether they need to be rewritten.
Okay, are you comfortable with giving a ballpark figure on how much like a consultation appointment would be with you for you to for us to discuss this? And
Those are complimentary.
okay, because we have a will in another state and we would like to get it North Carolina compliant. There's really no changes in it. But at the same time, you've brought up questions that we had, should we keep this will or should we get everything into a trust instead based on our particular situations? So, that would just be a complimentary consultation fee, or how does that work?
It's complimentary. We would meet. It's a 90-minute meeting. We would talk through your assets
Wow.
and your goals, and I'd make recommendations, and we can get more specific about your situation.
Okay, thank you. That's exactly what we were looking for.
Good.
You brought up some excellent points, especially because of people's situation. Like just thinking, maybe 10 years ago, I would have named my sister's executor, but that doesn't make sense. They're in their 80s now, right? And things change. One may be a widow, one may be going through this with their children. So their focus isn't going to be as sharp, or their time, and as age, they're looking at their own issues. So it's great. I like to look at our wills and trusts and documents kind of every election cycle, because it changes. Life goes on for all these people, and who you thought was capable or maybe front and center just aren't. They're not ready for it. They're going through their own issues.
No, I think that's a good rule of thumb, kind of the election cycle. I usually will tell people to review their documents or their plan every year. I can think of maybe 2 clients who actually do that with me every year,
We
and that's
take longer to
okay.
plan a vacation than our estate plan.
Yeah, I mean, as a rule of thumb, I have 3 situations when your plan should be examined or at least reviewed, and that's if your health changes, if you have any kind of health changes, and I'm not talking about getting the flu unless that's a serious event for you, but usually incapacity or a diagnosis with something that we can reasonably expect would require long-term care. That's when you should probably review your plan, make sure that these documents certainly meet the needs that we can expect. Change in financial situation, often that's related to health and issues, but I think people who create wills or estate plans when they are young and their children are young, their assets have changed by the time they've retired. And so making sure that your estate plan still matches the assets as they've changed through the years is good. And then changes in family. I meet with a lot of folks who are new retirees who, if they had a prior estate plan, that was done when their kids were still minors. And so they're now in the position, luckily, to be able to name their adult children as fiduciaries. And so that's where I think it's always helpful to just make sure the people in your life are still the people you want to serve in these roles or can serve in these roles. Or that's how you want them to inherit. And so it's a good rule of thumb to think about those situations. Along those lines, if you've moved, it's good to have that reviewed in a new state. But otherwise, I think an election cycle is a good way to remember that.
Hey, Kara, do you have any type of a spreadsheet or checkoff sheet to do preparation work before coming into you to maybe save time or so you don't leave anything off?
In terms of a preparation sheet, our intake form is about 5 pages long. And I think in to prep for our meeting, that's the information I look for. And I get two comments about these. Either people love that sheet because it asks them, I won't say forces them, but it asks them to actually review the assets and the ownership, and they take it seriously, and that leads them to realize, oh gosh, we didn't have beneficiaries named for this, or we thought this was jointly owned and it isn't. And so people have said this is a great exercise in making sure that they understand what they have. And it's a great exercise to pass along to their executors. And so often, if they do work with me and don't really keep their executors informed, when they pass away, the executor comes to me and will say, well, what do we know about their assets? I can at least pull this up and say, well, in 2025, when we work together, this is the information I have. And it at least allows them a good roadmap to get started in locating assets.
So is that intake form completed before we would meet with you initially?
It should be, because it's pretty in-depth.
So you, what, would mail that out to us? Is that what you would do?
We could email that to you or mail it to you, yes.
Okay, thank you.
The other comment we get about the form is that people either didn't tell me that they read it and didn't want to provide that information, or they think it's too time consuming. Or I'm told several times by people that that's not information I need to know. And so the reason I ask is because it's helpful in guiding that conversation. And that's why I mean, I ask for it so that I can help them. But to the degree that it is a little intense to locate all that stuff, I can appreciate that it's an endeavor. It's not something that can be filled out in a couple of minutes.
Well, in the same respect, though, if they're finding it overwhelming, can you imagine what their children or whomever is taking over the estate is feeling? And now
That's exactly
lugging
Save a
it.
you
lot of
to-
headache.
Yes, exactly.
That's exactly it. Now, one of the things that I've developed over the last year is, once I've worked with clients, if they want, I'm happy to provide them with a Word document. And it's intentionally as a Word document, it's not a PDF, but it's an outline of assets to categorize all the kinds of assets people have. I started on this Word document with my husband probably 5 or 6 years ago, where, with that very task in mind, Desiree, I said, I wanted someone to be able to read this and at least say, oh, good, I just need to make a call here and here, and be able to provide that information to someone who is stepping into our shoes. And I imagined myself sitting at someone's kitchen table without knowing anything else, and how frustrating that would be. And so with that in mind, I created this Word document. And I initially thought, oh, this will be a couple pages and I'll just provide the name of the institution and the account number. But over time, that whole document has grown, but I think it's grown into a very helpful tool that I actually sit down on the first of the year and review it. And so now we have, who is our financial advisor, who's our tax person, where are the spare keys to our vehicles kept? Where do we keep the titles to our cars? Where's all the paperwork people need to know about our marriage? And so I've really expanded this Word document. I've even given the code to my garage, because I think in your role with realtors, getting into a house sometimes isn't that easy. And so I started trying to think, if someone's sitting at my kitchen table and I'm not here to tell them, what information would they be asking me for? And so while I've certainly scrubbed my personal stuff from this document, I'm happy to share that outline with my clients so that they can use it as a springboard for their own ideas on how to categorize them. And I would say, the outline of this came from my head, but it's not something that I think you needed me as a lawyer to tell you what to create. There are books out there that are very helpful called I'm Dead, Now What? And it's a good book that uses writing prompts to identify some of the same information. There's a group out there that shows up on my Facebook feed called Knockbox, and that's Nokbox. Knock stands for next of kin. And I think it's a nice idea. I think they charge a bit for it, that I don't know if it's worth what they charge. I've never seen the the services in person, but I think it's a similar concept, helping you categorize and organize information about your assets. I will usually say people should keep their original documents in a fireproof bag. And in this area, it makes a lot of sense, not so much for fires, but for hurricanes. Um, and so if you're evacuating, certainly it's easier to take with you than a safe. But if you forgot to take your legal documents with you and they're at home and your house gets a leak in the roof, then they're still protected.
These were great questions. So and I don't know if you go through this with them. Now, if they're, let me see, there's one question. Now, so once they have all their documents done, and what should their next step be in making sure that if something were to happen to them, that their heirs know what to do next? So because I can't, I mean, like if it happens in 10 years, you might be retired. Like what
Right.
happens?
So I usually will do several things. I want to make sure our clients have digital versions of their documents, so PDFs. Um, I like PDFs because they're easy for them to pass along to their heirs. And I think about my dad, for example, who doesn't live here, but he sent me his documents by PDF, and I keep it in my inbox. And if I need anything, they're right there. And it has the his attorney's information in that email. Um, Email people tend to like. We also make copies of documents for their fiduciaries. Now, the fiduciaries are going to be executors, trustees, or power of attorney agent. And those are things that will make those copies, and sometimes people don't want to give those to the kids right away. Or other times they do, but we include our business card with those. So, and our name is at the footer of most of the documents so that people can contact us. But when I work with clients, they get a free meeting for their fiduciaries to meet with us when someone has passed away or if someone is incapacitated, so that their fiduciaries understand what these documents say and what they should be doing. With the healthcare power of attorney in particular, that's one that obviously we can never anticipate us needing. And so I will make a copy of that for your physician. And I encourage you to make sure that your physicians have that in your chart so that they know who to call if something happened. We also put the healthcare power of attorney on a flash drive. So if you're traveling outside of this area, I will say put it in your glove box or put it in your luggage, and that way it's with you.
There's one more question. Upon death, how are outstanding credit cards and mortgage payments handled?
So those are interesting because mortgage payments are attached to a home. So when someone passes away, um, the person who inherits the house either has to continue paying the mortgage, or if they don't want to, then the house needs to be sold. But the lender has the primary right to the home because the mortgage has not been paid yet. Other things like credit card debt or loans on a car or any other debt, even like your cell phone bill, for example, are debts that can and should be handled by the estate if you have one, and the executor going through probate has the legal authority to manage and pay or negotiate those debts on your behalf. A trustee similarly could do that. So either way, you're not going to die and get out of debt unless you have no assets. And so if you have more debt than assets, that's when usually the house would have to be sold, and those proceeds go to paying off creditors first.
What is a POA versus a durable POA towards estates?
So a power of attorney document is a legal document where someone can appoint an agent to handle health decisions or more financial personal decisions on behalf of someone. You can have separate documents, or you can have a single document that addresses both aspects. Most powers of attorney, and as of 2018 here in North Carolina, all powers of attorney that are created after 2018 are durable unless they say they are not. Being a durable power of attorney just means if the principal becomes incapacitated, the power of attorney still remains in effect. And so the durability really doesn't mean very much for folks anymore, at least here, unless you don't want it to be durable, in which case I would wonder why you don't want it to be durable.
Okay. Before we take off, anybody else have any questions or? So we will send this to you as an email in the next few days with all of her information, so that if you have more questions or do want to take her very gracious complimentary appointment, then you can go ahead and do that. Otherwise, if there's no other questions, we're done. That was fantastic, Kara. Thank you so much.
Thank you very much. Very helpful.
Yeah, and you guys had some wonderful questions, very good questions. So thank you again, and hopefully we'll be able to do this again soon.
Very
Thanks,
good.
Thank you so
Excellent.
everybody.
much.
Thank you.